Good evening and welcome to Family Law with Sushma Awtani. I'm Sushma and I work at a firm called Taylor Rose TTKW, who are a top 75 independent firm of solicitors with 700 experts nationwide. I'm also a member of Resolution, who are a family lawyers organisation who believe in a constructive, non-confrontational approach to family law matters. So today I'm going to start the show by talking about disclosure. तो जो family cases में होता है, family matrimonial finance cases में होता है, जब हम financial disclosure करते हैं, we use something called Form E to exchange this information. This disclosure takes up a great deal of a practitioner's time in one way or another. The exchange of financial information will hopefully lead to the parties being able to negotiate a settlement. If the parties are unable to negotiate terms of settlement, the court should have sufficient information and documentation available to impose a financial division between the parties. The parties are usually able to reach a settlement at or after the financial dispute resolution hearing, which is called the FDR. So, voluntary disclosure. Most solicitors will, at one time or another, agree to proceed with the process of voluntary disclosure. In the Law Society's Family Law Protocol, it is correctly noted that the pre-application protocol is annexed to Family Procedure Rules Practice Direction 9A, where it has been since April 2011. The protocol states that solicitors should bear in mind the objective of controlling costs and in particular the costs of discovery. Sometimes practitioners suggest the voluntary exchange process without properly assessing the benefits of doing so and whether the costs will be proportionate. The protocol goes on to state that the option of pre-application disclosure and negotiation has risks of excessive and uncontrolled expenditure and delay. This option should only be encouraged where both parties agree to follow this route, and disclosure is not likely to be an issue or has been adequately dealt with in mediation or otherwise. It is important that all parties adhere to the agreed timetable to ensure that there is no unnecessary delay. Paragraphs 7 and 12 of the pre-action protocol deal with the issue of disclosure. There is an obligation on both parties to make full and frank disclosure of all material, facts, documents, and other information. The practical method of disclosure is not prescribed, although many practitioners believe that both parties must complete the Form E and exchange it together with all mandatory filing documentation. Paragraph 12 states that if parties carry out voluntary disclosure before the issue of proceedings, and the parties should exchange schedule of assets, income, liabilities, and other material facts using the financial statement as a guide to the format of the disclosure. Documents should only be disclosed to the extent that they are required by the financial statement. Excessive or disproportionate costs should not be incurred. So, most cases may, if parties are reaching an amicable agreement and they are exchanging information in order to draw up a consent order, then in those cases Form E की इतनी ज़रूरत नहीं है. मेरे पास एक केस है जहाँ पे both the parties are reaching an amicable agreement, and जो दूसरी side है उन्होंने Form E मुझे भेज दिया है और कहा है कि अपने client को कहो कि उसमें वो fill up करे with all his documentation. And likewise, obviously, usko bhi she will have to do the same with her client. The problem is, Form E लंबा सा form है, बहुत सारे उसमें bank statements देने पड़ते हैं, बहुत सारे documentation देने पड़ते हैं, जैसे कि maybe mortgage statement, pension documents, valuations. So all this can be avoided with limited disclosure. So there are forms which we could send to our client which have limited disclosure and which would be sufficient to draw up a consent order. And sometimes that's usually the best way, but कभी कभी हमारे हाथ में नहीं होता, जो दूसरा साइड है उनको ज़्यादा disclosure चाहिए, when it might not be necessary because the parties are reaching an amicable agreement. And why they ask for that information is beyond me, because it's just going to increase costs when these could be avoided with limited disclosure, rather than having to fill out this lengthy form which is going to increase both parties' costs. So मेरे ख्याल से it's always better to have limited disclosure rather than filling out this form. In the alternative provision, the client can provide the solicitor with the documentation required to produce schedules rather than to complete the Form E. In cases where there is little money and the cost of full disclosure by the Form E would be seen to be excessive, it may be more sensible for the parties to exchange schedule of assets, liabilities, income and outgoings with select and relevant documents. It is very important that practitioners are clear with each other from the outset what the format of disclosure will be and the documents they will be attaching to their schedules. तो मेरा जो अभी क्लाइंट है उसके मॉडेस्ट एसेट्स हैं, उसको एक घर है, एक बिजनेस है, couple of bank accounts, and to be honest, limited disclosure would have been sufficient. So the documents that are needed for Form E, the form actually sets out all of these documents that the client must produce when completing the form. As these documents must be filed when completing the form for litigation purposes, none of the items should be deleted unless they have no direct application to the client. So for example, form में एक section है for business assets. अगर किसी का business नहीं है, तो obviously you cross out that section. If the client is waiting for a cash equivalent value of a pension, a note of the date when the request was sent to the pension trustee can be given in the Form E. It can be quite difficult to control documents if they are sent to the practitioner in a disorganized or piecemeal fashion. And so I would always advise clients to send the paperwork in one batch. क्योंकि जो finances हैं, it's not जो उसका fee structure है, it's not the same as dealing with the actual divorce. Finances, most solicitors या sub solicitors hourly rate पे deal करते हैं. In which case, अगर बहुत सारा correspondence आता जा रहा है and it's all in a piecemeal fashion, obviously आपके charges ज़्यादा होंगे. But अगर आप खुद organize अपना file करें, आप खुद mostly अपना form fill करें, it's not a difficult form to fill in, and you send all of that in one batch to the solicitor, then that will definitely save costs rather than sending things back and forth in a piecemeal fashion. So something that not everybody is aware of is self-help. So it is very important that clients are told at an early stage of litigation that they should not help themselves to their ex-spouse's documentation. तो क्या होता है, कभी कभी दो parties separate होते हैं and during the marriage they have been sharing each other's emails, they've got the login details to their bank accounts, so things have been pretty easygoing during the marriage. But once divorce proceedings are initiated, then one should not open the other person's letters, documentations, emails, bank statements, or anything of that nature which you would know that the other party would not want you to open. So it is very important that clients are told this at an early stage of litigation, that they should not help themselves to their ex-spouse's documentation. So जैसे मैंने कहा, even where they've been fairly easy going during the marriage about accessing documents, you need to be warned that this should stop when divorce proceedings are started. So the leading case in this area is the Court of Appeal decision in Imamam and Imamam of 2010. The Law Society's Family Law Protocol indicates at para 10.7.2 that it is a breach of confidentiality for one spouse to examine, copy, retain, or use a confidential document. The Court of Appeal described confidential documents as communications which are concerned with an individual's private life, including his personal finances, personal business dealings, and possibly his other business dealings, other stuff of personal confidentiality. A document will be confidential if one spouse knows that the other would not want them to look at the document or even have a copy of it. Simply put, one spouse should not look at documents belonging to the other unless they have been given permission to do so. For example, if the parties have exchanged documents at mediation or during the collaborative law process. The fact that the parties had previously given each other permission to look at documents cannot be relied upon if their relationship has broken down, and it should be clear that such permission is withdrawn. It is therefore sensible to write to the other side to withdraw such permissions given by the client. If one spouse gave the other permission to access their online banking, email accounts, or other online documents, then permission should specifically be withdrawn to avoid any suggestion that permission to access those documents remain post-divorce. The practitioner, clients should not give the practitioner any documents belonging to their spouse. And a number of statutes prevent one party accessing the other's documents. For example, the Data Protection Act 1998, the Computer Misuse Act 1990, and the Postal Services Act of 2000. तो एक केस में क्या हुआ था मेरे साथ, एक कपल है वो स्प्लिट हो गया था एंड आदमी घर छोड़कर चला गया था और औरत के घर सब लेटर्स, बैंक स्टेटमेंट्स कभी कभी आते थे, some, although he had forwarded the rest of the post on. By mistake, I think एक दो लेटर्स उसके पास आए और उसने मुझे स्कैन कर दिया कि ये देखो ये बैंक स्टेटमेंट आया है, इसमें ये लिखा है he's been irresponsible in his spending. उसने यहाँ पे खर्च कर दिए, वहाँ पे खर्च कर दिए हमारे पैसे, the finances that belong to the matrimonial pot वो use कर रहा है सब पैसे. And unfortunately, due to the Imamam principle, I was not able to open the scan or look at it, and मुझे वापस भेजना पड़ा client को और उसको बताना पड़ा कि due to the Imamam principles, she should not be opening any letters that are addressed to her husband because divorce proceedings have been initiated, and they should be returned back to sender. So that's very important. बहुत लोगों को ये पता नहीं होता कि because during the marriage they've been able to access bank statements or emails, they should not do so after the divorce has been initiated. So the best course of action is to for me to prompt you to change your online passwords and to ensure that you sever any iCloud or similar links with your ex-spouse's mobile devices. Although the spouse should not be looking at those documents, it is better to ensure that there is no access to them in the first place. अगर access ही नहीं है, फिर आप देखेंगे भी नहीं. As I explained, if the client gives the solicitor documents that do not belong to the client, we have to immediately return the documents to the owner, and the solicitor should not examine the documents or take a copy of them. Sure, so full disclosure of those documents should then be requested in the proper way during the proceedings. So, जैसे मैंने कहा, Form E is not very necessary, and where there's an amicable agreement between the parties, limited disclosure is usually sufficient. And I think अगर दूसरी पार्टी, दूसरा side insist भी कर रहा है, maybe, you know, it might be an idea कि दूसरा वकील कहे no, limited disclosure would be sufficient in this case because there's an amicable dealings going on between the parties. So in which case there's no need to spend excessive fees in filling up what is an onerous form. But अगर financial proceedings चल रही हैं, then obviously the Form E does need to be completed, and if it's a case जहाँ पे it warrants it and it's still going to be it's still going to lead to a consent order, even in that case, if it needs to be completed, then so be it, and I can advise you now or give you some information on what actually goes in the Form E. So page 1. The first page of the financial statement requires the important factual information, such as the names of the parties, their role within the proceedings, and the date of the form. So the warning notices on the first page are very important, and the client's attention should be drawn to these notices when sending the form to the client to complete. Of particular relevance is the fact that any person found to have been deliberately untruthful may have criminal proceedings brought against them under the Fraud Act 2006. The warnings also outline that proceedings for contempt of court may be brought against a person who causes a false statement to be made in the document verified by a statement of truth. Reality में क्या होता है? It's extremely rare for criminal proceedings for contempt It's extremely rare for criminal proceedings or contempt proceedings to be brought against a person who has deliberately lied on his financial statement. But we have to bear this in mind and complete the form as honestly as possible. There is a list of mandatory documents that should be filed on the form. It is important to note that the client may attach other documents to the Form E where it is necessary to explain or clarify any information within the form. It is also good practice to include documents where these would aid understanding and clarify the content of the form and the overall financial picture of the client. So, at the back of Form E, you've got a list of documents that need to be provided, and 12 months of bank statements need to be provided. You don't have to provide your credit card statements, but why not be helpful, open, transparent, and produce your credit card statements. It's always, you know, judges like it if you're open and transparent, and you know, if you're bending over backwards to help the judge, you know, there's nothing wrong with that. So जहाँ पे आप help कर सकें, ज़्यादा कुछ documents दे सकें to support your application, even if these are not in the list of documents on Form E, then my suggestion is to produce those documents to help the judge and your case. So, there is generally a large amount of standard information that is required, and this should be provided as quickly and comprehensively as possible to pave the way for earlier discussions. However, it is also critical that nothing is missed out. You can spark off expensive and intrusive investigations by omitting things. The court's view of your disclosure may be affected, and in extreme cases, the court may be led to assume that there are undisclosed resources available to you, even if this is not the case. So, for example, मैंने बहुत सारे Form E's देखे हुए हैं, and some जब हम prepare करते हैं, we are very meticulous and बहुत अच्छी तरह से prepare करते हैं because this could affect the outcome of the case. लेकिन some are quite disorganized, and pages could be upside down, back to front, there could be pages missing. Koi forms is jo main dekhti hu are very badly prepared. And it's impossible to read. They are so badly organized that you're left with the thought that perhaps you're being encouraged not to able to access the information on it. And agar aisa hua कि इतना वो mixed up हो गया है, then that makes the other side more determined to get to the bottom of the disclosure कि क्यों उन्होंने ये सारा mix up form हमें भेजा हुआ है. It could lead to suspicions as well. So, you know, it's best कि आप एक वकील करें जो meticulous हो, जो properly ये सब prepare कर सकें. And this is something that we do. तो we have हमारे पास बहुत सारा experience है Form E का. So it's always best that it is properly done. हम leverage file लेते हैं, उसमें dividers डालते हैं, and everything is properly organized to help the court and the outcome of your case. So, take advice. Whilst the form may look mechanical, there is always an issue of presentation. The things you write in this document you are stuck with and may impact directly on the outcome. Disclose everything. The thing that will stick longest with you is an overlooked asset. We are expected to carry out a careful survey of all we have, and we must disclose everything. Anything overlooked will have profound impacts upon how you are treated at court. अगर आपने एक भी चीज़ मिस आउट की या आपने कहा ठीक है इसको छोड़ दो, इसमें नील बैलेंस है, I'm not going to bother, और अगर जज को पता चल गया तो वो सोचेगा अगर इसने एक चीज़ के बारे में सच नहीं बोला तो और कितने सारे झूठ ये बोल रहा है. So it's best to be open, honest and transparent. Explain. Remember too that the court does not expect you to simply throw out the raw data. It is your job or your solicitor's job to make your explanations lucid and easy to access. So for example, कभी कभी मुझे लोग देते हैं अपने बैंक स्टेटमेंट्स जो स्टर्लिंग में नहीं है. It's always best to get sterling equivalents to make it easier for the judge to understand how much money is actually in that bank account because it's not in sterling. Give backup. Find the documents to confirm everything you can. The form has notes telling you excuse me, what must be produced, but bring in the further documents you need on top. Excuse me, ideally each element of your financial situation should be backed up by documents. जैसे कि सेविंग्स, आपको सब अपने सेविंग्स दिखाने चाहिए. Think about how you will appear. Estimates should be realistic, pessimism should be provable. Sounding generous to your spouse and appreciating their contribution may cost you nothing, but may impact on how the court views you. Excuse me. So it is fundamental to the process that each party gives full and frank disclosure of their financial position. And in fact, this obligation continues until the order is made. So for example, अगर आपने फॉर्म में fill up कर दिया, it's all complete, उसके बाद कुछ आपके financial circumstances में change आए, you are under a duty to disclose any changes that happen after you have completed Form E as well. तो आपको यो information volunteer करनी चाहिए, even if it's happened after you have completed your Form E. How you go about dealing with this aspect can make a significant difference to your legal fees. The more efficiently you and your solicitor work as a team to complete the form, the less time your lawyer will need to spend on it. तो जितना आप form fill up कर सकें, आपको करना चाहिए. And then you can work with the lawyer to fill out the boxes which may be a bit complex in nature. How you come across. You will want your spouse and the court to perceive you as transparent and open. You will not want to look grasping, moaning or mean. Okay, so we've got 4 minutes before we end the show. Once again, it's time has gone very fast. So what I would say is, अगर आपको फॉर्मी की issues हैं या कोई और भी issues हैं, and you need advice on separation, divorce, finances on divorce, or high net worth divorce, or any other family law matter, then मेरा number screen पे आ रहा होगा, which is 0207 600 1313, और आप ये नंबर फ़ोन करके कंसल्टेशन मेरे साथ बुक कर सकते हैं. जैसे मैंने कहा, it's good to have a meticulous solicitor because that will impact the outcome of your case. Also, finances, they are dealt with on an hourly rate. आपको एक ऐसा लॉयर चाहिए जो ज़्यादा टाइम नहीं लेगा, ज़्यादा एक्स्ट्रा काम नहीं करेगा. जैसे कि मैंने कहा, एक केस में हो रहा है, just extra work is being done, which is increasing fees. तो अगर आपके पास ऐसा लॉयर है जो ड्रैग कर रहा है क्योंकि आवली रेट पे है, कभी कभी केसेस 7 years 11 years होते हैं, एंड इट्स शॉकिंग. मेरे पास एक क्लाइंट आया था जिसने कहा कि मेरा लॉयर ने कहा 1 साल लगेगा डेट मिलने में. उसने चेंज किया, मेरे पास आया, एंड मुझे 2 महीने में डेट मिल गई. सो समटाइम्स when we write to the court and say इसको एंग्जाइटी हो रही है या एक्सेप्शनल सर्कमस्टांसेस है, जल्दी डेट मिल सकती है. You don't want to wait such a long time जहाँ पे आपको आप आवली रेट पे हर ईमेल, हर फ़ोन कॉल का आप पे कर रहे हैं 1 साल के लिए, जब 2 महीने में सब कुछ हो सकता है. मेरे जैसे मैं काम करती हूँ, it's best to try and finish the case to help the clients to move on. Otherwise they've got stress, anxiety, they're not able to move on with their lives because this case is over their head, hanging over their head for years and years and years. कभी कभी 1 साल, कभी कभी 7 साल, कभी कभी एक क्लाइंट ने कहा कि 11 साल हो गए. So we've got a minute and a half left to go. So that's what I would say is that अगर आपको जल्दी से अपना केस ख़त्म करना है and honest lawyer चाहिए, then you've got my details. You can give me a call and come in for a consultation because मैं जल्दी से केस ख़त्म करती हूँ. And I don't believe कि जो lawyers वो पैसे जो बनाते हैं, sadly there's a few जो drag करके केस, that money never lasts. What goes round comes round. So it's best to be open and honest and try and finish a case as soon as possible rather than dragging it out. And बेचारे clients, उनको तो कुछ पता नहीं होता कि क्या हो रहा है, क्या हम कर सकते हैं, जल्दी से डेट ले सकते हैं, नहीं ले सकते. तो I feel sorry कि वो इतने vulnerable position में हैं, and it's best to try and get it resolved. So मेरा नंबर तो स्क्रीन में आ रहा है, आप कंसल्टेशन बुक कर सकते हैं. We've got, I think, a minute to go. So what I would say is that hopefully आपका सब कुछ sort out हो जाएगा, but I'll be back next Thursday at 7 p.m. and from me and all the team at MATV, thanks very much for watching and have a good evening. Thank you.